order. Statement, the Lord Chancellor and Secretary of State for Justice. Mr. Secretary Clarke.
With permission, Mr. Speaker, and further to the written ministerial statement I laid in the House earlier today, I would like to make a statement. Last autumn, the Government launched 2 consultations on far-reaching plans to reform punishment, rehabilitation and sentencing of offenders, and on legal aid in England and Wales. Today I have laid before Parliament the Government's responses to these consultations. I am also introducing the Legal Aid, Sentencing and Punishment of Offenders Bill to give effect to those measures that we are taking forward that require primary legislation. Mr. Speaker, protecting the public from crime and punishing lawbreakers are the most fundamental responsibilities of the state towards its citizens. But the sad truth is that after 13 years of government, over 20 criminal justice bills, more than 3,000 new criminal offences and an explosion in the prison population, Labour left the system in crisis. Most of our prisoners spend their time behind bars, idling in their cells with ready access to drugs. A bigger scandal still is our reoffending rates, which are straightforwardly dreadful. Within a year of leaving jail, half of offenders will have been reconvicted of further offences. The same people cycle round the system endlessly, committing more crimes against more victims. The best way to reduce crime is to reduce reoffending, and that remains the central feature of our programme of radical reforms. Prisons must be places of both punishment and reform. Today I can confirm that we plan to deliver a full working week across the prison estate. We will legislate to extend powers to use money earned by prisoners to support victims. We have never proposed that community sentences should replace prison sentences, but we will introduce tougher, properly enforced community punishments where offenders work longer hours unpaid, at least 4 days a week. Drug abuse, Mr. Speaker, lies behind much, if not most, criminality in this country. It is not acceptable that drugs are too readily available in prison. We are taking forward plans to reduce addiction across the prison estate, improving security and introducing drug-free wings in jails. We must tackle other root causes of criminality, particularly alcohol addiction, mental illness and lack of skills. But we will ensure that we only put taxpayers' money into those rehabilitation programmes that actually work. Public confidence in the criminal justice system is unacceptably low. That is why we want to take forward plans for a new offence with a mandatory minimum prison sentence of 6 months for adults who use a knife to threaten and endanger. We will also consult on proposals to criminalise squatting, and we will bring forward legislation to clarify the law on self-defence. In addition, I can confirm our intention to improve the use of remand and to reduce the number of foreign national prisoners in our jails. Discounts for early guilty pleas have been part of the criminal justice system for decades, for good reason, and we consulted on changes to that system. Personally, I was particularly impressed by the representations of the senior judiciary and other criminal justice experts who said that increasing the maximum discount on offer for an early guilty plea at the earliest possible stage might result in the sentence served being too short in some serious cases. I considered and was hoping to address that problem. I considered addressing that problem by introducing a greater degree of judicial discretion, but we couldn't make that work. We have therefore decided to retain the present system. The consultation also produced strong opposition to the indeterminate sentencing framework. This was introduced by the last government and sold as a way of protecting the public from a small number of the most dangerous offenders, but it's never worked as Parliament intended. It's created a flawed system where thousands of offenders have already served their normal sentence or tariff, but no one can predict when or if they might ever be released. That is why, as the Prime Minister confirmed this morning, we are reviewing indeterminate sentences of imprisonment for public protection, so-called, with a view to replacing them with a more sensible, tough system of long, determinate sentences. Now, this will see judges handing down life sentences in a greater number of very serious cases, including mandatory life sentences for the most serious repeat offenders. Serious sexual and violent offenders will spend at least 2/3 of their sentence in prison rather than being released halfway through. We intend to return to the best aspects of the system before IPPs were introduced in 2005 by New Labour. Turning to legal aid reform, we have much the most expensive system in the world, except for Northern Ireland. It's costing £39 per head of population, compared, for example, with £8 per head in New Zealand, a country with a broadly similar legal system. The last government consulted on this subject more than 30 times since 2006, and still left us with the mess we now have to tackle. In some cases, the system encourages people to bring issues before courts where other solutions might be better. In others, it enables people to pursue litigation that they wouldn't contemplate were they paying for it out of their own pockets. And following careful consideration of more than 5,000 responses, I'm bringing forward proposals which I believe will ensure access to public funding in those cases that most require it, encourage early resolution of disputes instead of unnecessary conflict, and ensure much better value for money for the taxpayer. I can announce that we will retain legal aid in cases where people's life or liberty is at stake, where they are at risk of serious physical harm or immediate loss of their home, or where their children may be taken into care. In response to consultation, this will now include strengthened provision for victims of domestic violence and for children at risk of abuse or adoption, and the retention of legal aid for special educational needs cases. Legal aid will no longer be routinely available for most private family law cases, criminal negligence, employment, immigration, some debt and housing issues, some education cases, and welfare benefits. It will also no longer be available for squatters resisting eviction. We have also decided not to abolish, as we originally proposed, the current capital disregards for pensioners and for equity in the main home in assessing an applicant's eligibility for legal aid. We will not now introduce a £100 contribution from capital for those assessed as having £1,000 disposable capital or more. Mr. Speaker, what all this amounts to is a balanced and sensible package of reforms of the kind that the government was determined to achieve when we published our proposals and started to consult upon them. Our plans mean a return to common sense in the justice system, and on legal aid, the overall effect will be to achieve significant savings while protecting fundamental rights of access to justice. On sentencing, we will deliver punishment, protection, and a renewed focus on breaking the cycle of crime and reoffending. I look forward to debating the proposals upon second reading and subsequent stages of the bill.
Mr. Sadiq Khan.
Thank you, Mr. Speaker, and can I thank the Justice Secretary for advance sight of his statement. Our justice policy should be about protecting the public, punishing and reforming offenders, being on the side of the victim and bringing crime down. And that underpinned our record in government, which led to a 43% fall in crime, reductions in reoffending and serious improvements in youth offending rates. But this government demonstrates this isn't what matters in their approach to crime and justice. Instead, it's about cutting costs despite the impact they could have on communities up and down the country. Mr. Speaker, the government has seen sense and taken heed of opposition to cost-driven proposals to reduce sentences by 50% on early guilty pleas. A coalition of victims, the judiciary, justice groups, the Sentencing Council and victims groups rightly questioned the motivation and effectiveness of this policy. And let's be clear, the policy had been agreed by Cabinet. I asked the Justice Secretary on the Opposition Day debate on sentencing whether the Prime Minister agreed with him, and his response was this was an entirely collectively agreed policy. So it's no good Number 10 distancing himself from this. We also heard the Justice Secretary in oral questions last month say it would survive the consultation. And of course the benches opposite voted against our motion opposing this proposal, well some did, some had the sense not to, on the 23rd of May. Mr Speaker, can the Justice Secretary outline why the Prime Minister ditched this proposal when the government was so wedded to it just a matter of weeks ago? Can he explain when the decision was taken to change the name of the bill from the Legal Aid and Sentencing Bill, as it was called up until late last week, to the Legal Aid Sentencing, and I like this, Punishment of Offenders Bill? What was he hoping to achieve by tinkering with the title?
Bit of a smoke screen.
Mr Speaker, we know from the impact assessment provided with the Green Paper that removing the option of remanding offenders in custody for certain cases could save £50 million and 1,300 prison places. I note this proposal still remains. Would the Justice Secretary outline to the House the view of the Magistrates Association on this proposal, and whether he believes it is supported by the Police Federation and by ACPO? In the past 13 months, Mr Speaker, we have seen broken promises on minimum maximum sentencing, on prison building and on knife crime. He today proposes a new offence of a mandatory custodial sentence for knife possession in aggravated circumstances with a minimum sentence of 6 months. Even this proposal is less than that promised to the electorate in the Conservative manifesto, which said, "We will make it clear that anyone convicted of a knife crime can expect to face a prison sentence." It's still a broken promise, and tinkering with the title of the bill won't change that. Mr Speaker, on IPPs, I have consistently questioned the Justice Secretary on how he will ensure the safety of our communities when considering which offenders ought to be released and when. Once again, the impact assessment helpfully tells us that financial savings in doing this will be, and I quote, "sizeable." From this, it's obvious that the focus is saving money and not what's in the best interest of the public. Today we find he's to undertake, and I quote, "an urgent review of IPPs with the view to replacing them." Can he explain, Mr Speaker, to the House why he needs another review when he has had 13 months, a Green Paper and a consultation which he has consistently described as the opportunity to review IPPs? Mr Speaker, can I ask the Justice Secretary how he reconciles losing thousands of frontline experienced prison and probation staff with the desire to increase the numbers of offenders diverted into specialist drug, alcohol and mental health facilities, and also with more prisoners working who will clearly need more supervision? Mr Speaker, I turn now to legal aid. The proposals on legal aid have been roundly criticised across the board as devastating social welfare law. Has the Justice Secretary...
Order. There was too much noise when the Secretary of State and Lord Chancellor was addressing the House, and once again there is too much noise. Let me just say to those who are making a persistent noise, stop it or leave the chamber. But do not for one moment suppose that making that noise you've got the foggiest chance of being called to ask a question. Mr Sadiq Khan.
I'm grateful, Mr Speaker. I turn now to legal aid. As I said a moment ago, the proposals on legal aid have been roundly criticised across the board as devastating social welfare law. Has the Justice Secretary seriously considered the alternative funding options put forward by, for example, Justice for All? Does he accept that his changes will have a huge impact on the viability of many law centres, on CABs and high street practices up and down the country that do an enormous amount to provide access to justice for some of our most deprived citizens? Mr Speaker, the Prime Minister claims that the whole point of a Green Paper is to listen and be ready to change one's mind. Why has the government not made any substantive changes around its proposals on social welfare legal aid? This morning the Prime Minister said savings that would have been made by the 50% sentence proposals will be found elsewhere in the MOJ budget. Can the Justice Secretary explain to the House exactly where these savings will be made and when? Mr Speaker, we are seeing cuts to the police, cuts to prison staff and probation trusts. But where is the strategy to cut crime? The government's policy on crime and justice are in shambles. We've always known you can't trust the Tories on the NHS. Now it seems you can't trust the Tories on law and order either.
The Secretary of State and Lord Chancellor.
Yes, well, I can confirm what the Honourable Gentleman says, first of all, that the proposals I presented for consultation in the Green Paper were the proposals of the Prime Minister the whole Cabinet and I, and the proposals I'm putting forward today in the response to the consultation are the responses to the comments we invited by the Prime Minister, the whole Cabinet and I. Indeed, we had a discussion at Cabinet this morning. We run a collective government. I remind the honourable gentleman that we carried him with us in our Green Paper on the 7th of December in this House. It's all accessible in Hansard. His reaction to what the Prime Minister and I were saying then was that this was a perfectly sensible vision for a sentencing policy entirely in keeping with the emphasis on punishment and reform that Labour followed in government. We carried him with us then. I have hopes if he can look at the consultation and listen to the arguments, we will carry him with us again. But if he wants to turn and change his mind, he's free to do so. The early guilty pleas were a genuine attempt to help victims and witnesses who are mightily relieved if they hear that the person accused has decided to plead guilty. If it had worked, it would have saved a very great deal of money and time for the police service, for the Crown Prosecution Service, as well as for the prisons. What I did, and I don't know what quite his view is, what I did was take particular regard, actually, to the legal opinions I was getting from serious members of the judiciary and others, that if you looked at the arithmetic, it just went too far with some serious cases. I said I thought it would survive a week or two ago because I thought by putting in some judicial discretion I could solve the problem. Well, you can't. And so for that reason, we are sticking with the present system, and that is what consultation is all about. On remand, we have consulted, and we are carrying on with our proposals. It seems to me, at the present time, to carry on with the system whereby people are refused bail in a case where everybody knows they're not going to be sent to a custodial sentence if they're convicted at their final appearance is simply not the best use of the very expensive places in our prison system. It's cheaper to put our prisoners in the Ritz, and many of them would like to be there, but because the public prefer them to be in prison, we keep them in prison. But the remand proposals, I think, are extremely sensible. The knife possession proposal is put forward to give a message about the seriousness which regard possession of knives. I don't think the honourable gentleman expressed an opinion on it. I would advise him to support it. I think it's a perfectly sensible measure. On IPPs, which I've said we are minded to repeal and replace with what would really be a better version of what preceded IPPs, I can only refer to him just for the consultation. The attacks on IPPs from sensible people. There is a man called David Thomas QC who actually writes the Bible on sentencing as far as criminal law practitioners are concerned. Thomas on Sentencing is the book if you practice in the courts. He described IPPs as an unmitigated disaster. And what we are actually doing is carrying out a review to decide what will replace IPPs by way of a strong system of determinate sentences that protects the public. On legal aid, again, I could find a quotation, I could quite rapidly find a quotation where he said if they were in government they would be cutting legal aid. I do think he has nothing to say on legal aid that really challenges the case I put forward a moment ago. On citizens' advice bureaus and other forms of general advice, hope to be able to say something at second reading. I am making advances, but we will see how much we are able to come forward with, because I do agree, given we think there are better ways of resolving problems, the CABs and other voluntary bodies provide the better type of advice sometimes than adversarial lawyers. He asked where the savings are coming from and comments on the probation service and elsewhere. Firstly, I've had protracted negotiations with the Chief Secretary to sort out the finances of our department, given some of the things that were left behind, and we have resolved all those. We're making £2 billion a year savings over this period out of the total expenditure of my department, and there is still £100 million we're looking elsewhere. We're not cutting any particular area. We are achieving efficiency. Half of what we're achieving is coming from administrative savings. If we have further policies, we will, in order to find the money that we're not saving, then I will come forward with them. I prefer to proceed with proper policies in joined-up writing, upon which I have consulted my colleagues and got approval, can then come to the House. And that's now, I'm now looking how to make sure the final touches to the major savings we're making in my department can be achieved in the light of this consultation.
Sir Alan Beath.
Speaker, while the Justice Committee will continue to have concerns about the extent of the legal aid changes, can I press him on sentencing? Do his Cabinet colleagues recognise that if we want to protect our citizens from crime, it will not be by tough talk or favourable headlines, it will be by appropriate sentences geared to make offenders face up to what they have done and change their behaviour. And sometimes resources are required to do that and shouldn't be commandeered by the prison system.
Yeah, well, I agree with the right honourable gentleman. Talking tough is easy and most politicians do it. Delivering tough is rather difficult. As the Labour Party discovered only too often. I won't use the quote I've used before, the honourable gentleman knows perfectly well. And I quite agree. Of course prison is the right punishment for serious and violent offenders who will keep being sent there for long sentences whenever they justify the punishment so they can make reparation. But you tackle crime by also trying to reform them, get more of them to go straight, and reducing reoffending and providing other ways in which you can stop the accumulation of more victims and more crimes by people who come through the system. I think that is accepted by my colleagues. We are giving up the increases remorselessly at huge expense in the prison population. We're looking for a more intelligent way of protecting the public, which is our first and principal priority.
Sir Gerald Kaufman.
Happy birthday.
Mr. Speaker, thank you. Mr. Speaker, is the right honourable gentleman aware, he certainly should be because I've told him a number of times, of the dire effect upon my constituents of the action he has taken already with regard to attacking citizens' advice bureaus, undermining legal aid and taking the wrecking ball to the South Manchester Law Centre? Is he further aware that what he has announced today will complete the process of making access to justice a prerogative of the rich?
Well, I could answer each of those three things. I mean, most of the cuts being made to citizens' advice bureaus and so on are being made by local government. We are not the principal. No, we are not the Department of Justice is not the principal contributor to citizens' advice bureaus, but I've already said the government as a whole is going to actually assist those who give quality, worthwhile advice of the kind that's required to very many people who actually don't need legal aid and an adversarial lawyer. It's not the best way of proceeding. Court closures, we've debated before. We inherited hundreds of over 100 underused buildings, which I'm afraid we had to actually tackle and rationalise and so on. And the package of legal aid reforms is tackling a system which has got bloated in recent years, which his government kept talking about reforming, but never actually did, because it was rather typical under the last Prime Minister, an inability to take decisions about exactly what to do about an out-of-control government. And when we finish what he says of these draconian reforms, we will have still by far the most expensive legal aid system in the world after I have made our so-called cuts.
Order. In the interests of maximising the number of contributors, I appeal to honourable and right honourable members for short questions and, indeed, for short answers. Anna Soubry.
Would the Lord Chancellor agree with me that it was the last Labour government that, having introduced IPPs, then changed the law in order for no other reason than to reduce the prison population? And in suggesting the thoroughly good idea that we now scrap IPPs, this would ensure that the public, the victims and indeed offenders were better protected and had greater justice.
I agree with my honourable friend. I think the reason why they introduced IPPs was because they were reducing the time automatically served of a sentence from 3/4 to a half. So they introduced what sounded like a tough measure of these new indeterminate sentences. It immediately went wrong. They introduced more legislation after 2 years to try to reduce the numbers. I regret to say my first effort was to go in the same direction and reduce it even more. I hope I have a support in saying the best thing is to get rid of them and go back to a sensible system of long, determinate sentencing.
Mr George Howarth.
Mr Speaker, the right honourable gentleman should be aware that part of the problem he had with his original proposals was his failure to establish the case for community sentences as an alternative to prison. In his statement, he refers to new, tough community sentences. Can you describe what the characteristics of a tough community sentence might be?
In fact, I never advocated, nor did the government, as it were, the replacement of short prison sentences with community sentences. I have some very curious opponents and sections of the media, and it was one of the bees they got in their bonnet almost as soon as we started. But we never proposed that. I do think community sentences need to be carrying public confidence so that magistrates can consider them properly as an alternative to prison in suitable cases. They do now, but more would. What I have in mind with tougher sentences is better organised ones, so that, for example, unpaid work, which is one of the best community-based punishments one can have, unpaid work, doing work of genuine, worthwhile work for the community, should be better organised, better disciplined, shouldn't have to be fitted in with the odd day over several years, should be better organised on the day, and should be based around a pretty normal working pattern of so many hours each week when it's done. That, and making more use of curfews and tagging, there are plenty of things we can do to build up public confidence in community sentences, which I'm sure he and I both agree would be a good thing to do, and which we both agree is lacking at the moment.
Mr. Edward Lee.
What on earth did my right honourable friend mean today when he said that he would introduce drug-free wings in jails? Doesn't he understand that to the public that is an extraordinary statement? They believe that all parts of all jails should be drug-free, and to them this sums up the irretrievably soft attitude of our entire prison system. In particular, will he protect our people, vulnerable old people, from burglars, and promise the House today that all burglars of all private dwelling houses will be put in prison?
Well, on the first point, I share my honourable friend's amazement, or I'm sure anybody does, on their first introduction to the criminal justice system. But the fact is, drugs are very widely available in our prisons. And 9% of people who've taken heroin say they first took the heroin in prison, where they were introduced to the drug. So I'm sorry I have to refer to introducing drug-free wings, but that is what we're proposing to do, and we're going to address the security and the rehabilitation and the other problems that are necessary to do that. Of course, burglary is always a serious offence. It's actually rising at the moment. One of the ones that do, nothing to do with the sentence level, it is actually rising at the current time. It's up rather alarmingly compared with a year ago, and I regard all burglary, particularly household burglary, but all burglary, as a very serious offence. But in the end, the punishment has to fit the particular crime, and I'll consider what my honourable friend says, but I think there should be a limit to the number of automatic sentences according to what it says on the label, and proper sentencing that's directed to what we both agree is the first priority, the proper protection of the public.
Fiona McTaggart.
Mr. Speaker, in view of the mistakes that his team has previously made about their policies in relation to women, what risks does he see in making domestic violence a gateway to access to legal aid? Does he think that it'll mean that people are sceptical about claims of domestic violence among its victims?
Well, we have considered, we've defined domestic violence, and we're not sceptical at all. Indeed, I hope the Honourable Lady is pleased. One of the things we've done is actually look again at domestic violence and extended legal aid more than we originally proposed to those cases where domestic violence is concerned. And I think our policies to women actually probably have her fairly wholehearted support. I mean, women in prisons have a particular policy towards. We're actually following the policy of the former government. We're following the policies of Lady Causton, and we are actually, at the moment, the number of women prisoners is going down. It's the number of adult males that is still slightly rising.
Andrea Ledson.
Thank you, Mr. Speaker. Can my right honourable friend reassure the House that, in spite of the changes that he's making, the support for children remains there, and that in the case of domestic violence, child abuse, child abduction and enforced child adoption, that there will be legal aid available to make sure that children do not suffer?
To give a short answer, Mr. Speaker, all of those, and I agree with my honourable friend, all are an important priority.
Mr. David Hanson.
On foreign national prisoners, just so we can judge the Lord Chancellor's performance, could he tell us how many fewer foreign national prisoners there will be in jails in June 2012. And perhaps he could also tell us which new countries he expects to sign agreements with over the next 12 months, because I think he'll find from experience it's not as easy as he thinks it's going to be.
Yeah. Well, actually, he'll be surprised to know I can tell him there are 1,000 fewer now than there were when the previous government left office. But I'm only going to agree with him that I do realise it's very difficult to achieve. We are, of course, pursuing transfer of prison agreements. We have the new transfer arrangements with the EU coming into effect, and we are working with the Borders Agency to try to improve their effectiveness to moving people promptly. But we are working at it, and so far we're doing 1,000 better than he did.
Mr. Robert Halfon. Thank you, Mr. Speaker. Harlow Welfare Rights and the CAB are deeply concerned about the proposed centralised telephone service for all but emergency services. Can my honourable friend assure us that this will not add an unnecessary level of impersonal bureaucracy and prevent advice from reaching vulnerable people? And will he also look at clinical negligence legal aid so that those who are harmed have access to justice?
Better, Mr. Speaker, refer my honourable friend to the consultation document. We have readdressed this question of listening to his representations and other people, because I think he's taken up in the past. We have much more closely defined the use of the telephone advice system and concentrated those areas where we think it is of value, and I think he'll find when he looks at our response and consultation in some detail that we've gone in the direction that he would have wished.
Mr. Graham Morris.
I'm grateful. I do note that the Justice Secretary tells us that legal aid will no longer be routinely available in clinical negligence cases, and clearly this is a huge problem, people being denied justice and compensation, those suffering injury or worse due to malpractice or clinical negligence. Could the Justice Secretary explain what his justification is for that?
Yeah. Well, 80% of clinical negligence cases are already done by no win, no fee, and only 20% by number are done by legal aid. And that's why we think that no win, no fee is probably the better way of going forward, and also why we have done something through we're going to implement Sir Rupert Jackson's recommendations to make sure the costs to all the parties are got down in proportion, because far too often the health service finds itself paying out at least as much in legal costs as it is in compensation to the victims under the pre-Jackson rules. But negligence cases as a whole have steadily moved into the no-win, no-fee way of proceeding for those that can't afford it, and you get wider access this way because legal aid is restricted by a very, very tight means test.
Mr. David Ruffley.
Thank you, Mr. Speaker. Longer sentences on their own have clearly failed to cap reoffending. Could I therefore urge the Lord Chancellor to press ahead with his radical and right-wing plan to get private companies into prisons to deliver serious rehabilitation that actually works?
I'm grateful to my honourable friend with whom I agree. And actually, of course, one of the things to address are the costs of running the prison. We all want to address the efficiency with which the prisons are run, just as much as we wish to address who's sent there and how many we can accommodate. And I'm glad to say we've carried out a very successful tendering exercise, and we have saved a lot of money by, I think also improve the regimes potentially in these prisons by going through the exercise. We intend to do the same thing again. Regardless, I have no ideological hang-up about whether the successful bidder is a public sector bidder or a private sector bidder. We want the best bidder, best quality regime at the lowest cost, and that has to go hand in hand with all this sentencing reform. This is exciting, but the other also is a much better way of running a prison system.
Order, could I just very gently, in a jocular fashion, say to the Secretary of State that he shouldn't be like a cruise ship in rotation. The House wishes to hear him. He swivels around. It's helpful if he can face the House, and we'll be obliged to him if he does so. Sheila Gilmore.
Thank you. Thank you, Mr. Speaker. The Secretary of State has made much of his desire to have alternative dispute resolution, which he considers to be better, for example, in family law. Presumably he's thinking of mediation. Has he made any realistic assessment of the costs of that, and on whom those costs would fall? Will they fall on individuals, or is there going to be a cost, perhaps to his department, which would actually undermine the reductions he's hoping to achieve in legal aid?
Yes, my apologies to you, Mr. Speaker. I think probably the problem in my political career is I haven't swivelled enough on occasions. But as far as mediation is concerned, I do believe it's a much better way of resolving all kinds of family and other disputes. The taxpayer will continue to pay for mediation. Indeed, the mediators will be trained lawyers who take part in a much better process of resolving disputes for many people. And we are actually planning to increase the amount that we're going to spend on mediation by, I think my honourable friend tells me, £5 million in order to get the savings we're going to get by reducing the amount of unnecessary or necessary adversarial litigation we're funding.
Helen Grant.
I agree that mediation, though, is no panacea, and actually it can fail badly in family cases where there's an imbalancing power.
Well, my honourable friend has much greater expertise on the practice of family law than I do, so I do listen. I do listen to my honourable friend's opinion with very great attention. I've discussed these matters with her before. We've got to get the balance right, but I do think, at the moment, the very generosity of the legal aid system compared with other systems is getting more things into adversarial litigation than it otherwise would. I do think the expansion of mediation is the better way of proceeding, and I hope my honourable friend will contribute with her expertise to our development of the mediation system.
Lisa Nandy.
Secretary of State has spoken about the need for alternatives to the courts, but can he tell us what alternatives are available to victims of human rights abuses by multinationals, as in the Trafigura case, if the success fee on which many of these cases depend is no longer recoverable?
If, as I gather from her question, I'm not sure about that case, it was being conducted on a no-win, no-fee basis. Well, I announced to the House a few weeks ago the changes we are proposing to make in the light of Sir Rupert Jackson's recommendations. It will become much cheaper for all the parties when they are introduced. As far as legal aid is concerned, I mean, big things like human rights cases, that legal aid will still be available in suitable cases. We're not resiling from those areas where the taxpayer needs to finance the small man against the state or the giant administration.
Yes. Tom Brake.
Many aspects of this announcement, including the greater clarity on sentencing and the measures to tackle drugs, and indeed the improvements that have been made to the original proposals in relation to legal aid. Can the Secretary of State confirm that the government remain committed to restorative justice, which has a very high satisfaction rating with victims, remains committed to probation, which is key in terms of tackling reoffending, and also to the not-for-profit sector, and that no further cuts will be made to the legal aid budget or to probation, and that he will work very hard to ensure that the not-for-profit sector receives additional funding to support their work?
Well, firstly, we have recommended the extension of restorative justice from the start, and the more I come across it, the more it obviously is very welcome to victims and can be made very successful. So we're carrying on unswervingly on that. We intend to make more use of the restorative justice system. I agree with the honourable member about the importance of the probation service. If we're tackling reoffending, I think we try and get a better probation service where it needs improving, but you won't deliver improvements in reoffending if no one's supervising the offenders or supervising the behaviour on licence and all the rest of it. I have seen reports suggesting that we're going to fill the gaps, so-called, in our funding, which are actually pretty small compared with what we're sending overall, by somehow just cutting the probation service. I can assure him the probation service is no more singled out than anywhere else. We're looking for efficiencies everywhere, but we're not simply bouncing away from one thing in order simply to cut back the probation service to save money.
Yasmin Qureshi.
Thank you, Mr. Speaker. Can I ask the Lord Chancellor to reconsider the provisions for Citizens Advice Bureau? My local Citizens Advice Bureau is a Bolton one. Last year saw 14,000 of the most disadvantaged and vulnerable people in my constituency. I really would ask the Lord Chancellor to reconsider the question of provisions for Citizens Advice Bureaus.
Well, only 15% of CAB funding comes from my department, and about half of Citizens Advice Bureaus don't receive any legal aid funding at all. But I agree with the Honourable Lady about the value of the good Citizens Advice Bureaus. They vary in quality, but the best ones are very good. So I am concerned that we should do what we can to strengthen this area. So are my colleagues in other areas affected. Across the government, we are considering what we're going to come forward with in order to help citizens' advice bureaus, and I'm doing my best. We're going to settle eventually on some support. It won't be as much as they all want, but we will be able, I think, to help.
Mr. Philip Davis.
I congratulate my right honourable friend for listening to the consultation and for rowing back on some of the more damaging proposals. There's clearly much in this, though by no means all, that we can support. But one thing that I've learnt is that the government are proposing that people who breach a suspended prison sentence should be punishable now by a fine. Can my right honourable friend take this opportunity to make it clear that anybody who breaches a suspended prison sentence should only have one punishment available, and that's to be sent to prison?
Well, I'm grateful for my honourable friend's kind remarks, which he began. If, as it turns out, he does agree with quite a lot of the judiciary on the proposal for a discount for early guilty pleas, I hope he's equally in line with the judiciary on such things as the abolition of indeterminate sentences, and we'll all begin to make some worthwhile progress on the whole field, working collaboratively together. Suspended sentences are normally punished by serving the suspended sentence on top of anything else, but all these cases require a little more flexibility, and all we're adding is a possible flexibility which would be used in some cases adding a fine rather than just making the total sentence, for example, far too long. You might want to put a fine in and find some other way of dealing with the offender. I mean, Parliament, of course, is entitled to specify sentences, but if we do it in too much detail, we fail to do justice because we don't leave enough leeway and enough options to the judges and magistrates who are sitting hearing about all the facts of a particular case and all the circumstances of the offender.
Mr. Steve McCabe. Is the Justice Secretary now on probation, and does he anticipate time added on or early release?
Well, I've been on probation for about the last few decades, I think, but sooner or later I'll get the hang of it. But I'm working at it, and I'm seeing to the job. No, I'm not going to start launching in my description of the reports in the newspapers. It's sort of, most of my colleagues, I'm sure, envy my ability to get in the headlines. But the truth is rather far away from all that. The Prime Minister and I and the Cabinet have developed these policies together. We have moved along together. Yes, we have. Yes, we have. Yes, we have. We were saying the same things about policy 12 months ago, and we're saying the same things about policy today. And what matters is whether the policy actually works. These proposals will really be judged by whether or not in 3 or 4 years' time people can see that we have sorted out the appalling mess that we inherited in the criminal justice system from the party opposite.
Mr. Tony Baldbury.
To reduce reoffending, it's not only going to require painstaking work in prisons, but also working with offenders when they actually leave prison, actually at the prison gate and from onwards. Could my right honourable friend tell the House a little more about what funding and how voluntary and community groups are going to be able to access funding to support offenders when they leave prison and in those critical few months and weeks after they leave prison?
Well, this is where we have our proposals to greatly improve what is done to improve rehabilitation and reduce reoffending by using a payment by results system of paying normally consortia of people who come together to rehabilitate prisoners by the results they achieve. We already got the first pilots coming along. We have contracts in Peterborough. We now have one in Doncaster. We've got some about to start in Manchester and several other local authority areas. Ideally, a private sector body raising the capital, perhaps, a voluntary body, a not-for-profit body can come together in a suitable consortium, as my honourable friend says, firstly to start doing something about the prisoner who is in prison, and then following up and trying to make sure that there's far more likelihood that he will not offend again when he leaves prison. And the payment by results approach to rehabilitation is one of the most significant innovations this government is making in this field, and it's making very, very good progress.
Yvonne Favart.
What assessment has the Secretary of State made of the availability of face-to-face welfare advice from advice agencies such as Citizens Advice Bureaus and law centres in 2013, when the Welfare Reform Bill comes into effect at precisely the same time that welfare benefits are removed from scope?
I have already said that I'm not in a position today to say what we can do to support citizens' advice bureaus and other similar organisations providing advice in the legal field and in welfare and so on. The government is actually considering that, and I hope we will soon be able to come forward and make an announcement. Part of the problem is relevant to my field, but it extends into other areas as well, like welfare reform. And we are conscious of the fact that, as a government, we do have to do something to fill some of the unavoidable gaps that have been left at the moment by mainly local authorities being forced to cut back on the grants they can give.
Liz Truss.
This government inherited the most expensive criminal justice system per capita in the world. Could I suggest that with £100 million being spent on administering legal aid through the Legal Services Commission and having 3 different departments of NOMS all doing separate kinds of commissioning, not to mention the extremely high cost per prison place, there are many areas where savings can be found without cutting frontline services.
We are abolishing the Legal Services Commission because one of the most frequent complaints I get about the system is the sheer bureaucracy of it, and it's had its serious problems in the past. We save £8 million a year, I'm told by my honourable friend, the member for Huntingdon, simply by bringing it in-house, as we're doing, but we intend to save quite a lot more on the administration system of that. It's just hopeless if, with our prime duty of protecting the public, we waste money in this area and simply make it one of the most expensive and fastest growing areas of expenditure in the government range. We hope to make it effective, targeted on what we really should be doing, which is protecting the public from crime and giving access to justice for the vulnerable.
Mr. Jack Dromey.
Mr. Speaker, legal aid is a lifeline to those in need, often at a time of crisis in their lives. This bill and government cuts to local government expenditure will cut that lifeline to tens of thousands of citizens in Birmingham and threaten the future of our Citizens Advice Bureau and advice centres. Does the Secretary of State not accept that justice for the better off only is no justice at all?
That's just a very broad-brush defence of what the honourable gentleman believes is the need to carry on paying £38 a head per taxpayer for the present system of legal aid that we have. Of course, some legal aid is absolutely essential, crucial to the liberties of our subjects, the standards of our society, that we provide legal aid for people in extremists who otherwise have no means of urging their cause. But we have this grand across-the-board system which is financing sometimes an inferior way of resolving disputes if you look for better methods of doing it. And that will apply in Birmingham as in elsewhere. The last government knew it had to be reformed. They simply couldn't make their minds up what they were going to do to reform it. And we are actually making some very well considered, consulted on, thus modified to a certain extent, programmes for getting it back to a sensible size.
Mr. William Cash.
The Lord Chancellor referred to the fact that he was personally impressed by the representations of the senior judiciary. And in view of the fact that they said that it wouldn't be right, either as a matter of principle or of practice, to go beyond the maximum discount of 1/3, who are the wishy-washy Liberals who actually induced this row and all the fuss and the problems that we've witnessed in the press over the last few weeks?
Well, we did have quite a lot of support, and they weren't all wishy-washy Liberals, isn't there? We also had some opponents who were opposing it for reasons which I personally completely disagreed with. And I personally was impressed by the input I got from serious people in the criminal justice system who, of course, are all used to the discount for early guilty pleas. Everybody who's ever had anything to do with criminal justice knows there has always been a discount for pleading guilty early. The public don't know that, and they don't like it when they're first told it, but actually there are good reasons for it. But a half proved too far. I couldn't find any other way of resolving it and getting over the undoubted difficulties placed. So if there are any bleeding-hearted Liberals left who still think we're going to half, I'm sorry to disappoint them. But the fact is, at least my honourable friend and I are now agreed on where we are.
Kate Green.
The Secretary of State will be aware that many prisoners have very poor levels of skills and limited work experience.
Can he tell us how his plans for prisoner working will improve their employability prospects when they leave prison, and what plans he has to link education with prisoner working?
Well, I agree with all the Honourable Lady's sentiments, and we'll try to produce programmes that deliver what she obviously hopes we will do. Firstly, we have all the work experience in prison we're going to provide. We're going to try and organise serious work as much as possible with the collaboration of outside businesses who, for social responsibility reasons, are often very attracted to get involved in this area. The work inside prison should be more meaningful. It should be more like the ordinary disciplines of the working life outside. It should, with luck, add to the training and employability of those inside. And then we have to tie in with the Department of Working Pensions work programmes and what they do to try to get skills and employment outside. This is having a job to go to greatly increases the chances that an offender might not offend again, have more victims, might start to go straight. So it's a very important area, and we are proposing to make very significant changes in tackling this side of the problem.
Mr David Nuttall.
Mr Speaker, last year's Conservative Party manifesto stated many people feel that sentencing in Britain is dishonest and misleading. In order to start to restore the public's trust and confidence in our justice system, if it is a good idea to introduce minimum prison sentences for certain knife crime, why can't we have such minimum sentences for other classes of crime?
Well, the honesty in sentencing is because it's not at the moment explained to people that the sentence is so much in prison and then likely to be a further amount actually on licence but subject to recall outside. And we will see if we can address that and make people understand more clearly what the sentences actually imply. It was the previous government, it wasn't us, who moved from 2/3 of the sentence being served to half the sentence being served, a move which we're intending to reverse in the case of the most serious sexual offence and violent criminals when we're moving away from IPPs to a more sensible system of determinate sentences.
This is Jenny Chapman.
Mr Speaker, can I welcome this latest and expertly executed U-turn from the government? Yeah. But can't the Justice Secretary see that this whole row, the cuts to probation, cuts to youth offending teams, allowing banned people to volunteer in classrooms, failure to close all the loopholes on monitoring sex offenders, all of this together creates a very ugly picture of the government's attitude to victims of crime?
Yeah. Well, I've done many U-turns in my time, and they should be done with purpose and panache when you have to do them. But I actually don't think this is a U-turn at all. It's just becoming... No, I don't. Let me explain.
What opposition front bench is taking some sort of tickling powder or something. I've been listening with bated breath to the Secretary of State for the best part of 20 years, and I want to continue listening to him. Secretary of State.
What we're aiming at is a package of radical reform of sentencing to make it more effective in protecting the public and at the same time making a very substantial contribution to reducing the country's deficit, which I think is vital to our economic recovery. We consulted on what is a leviathan of a bill with a huge range of proposals. We have consulted, we have changed some of it, we have come up with, I think, with what we intended to have. I think it's a better balanced package, actually, of good reform of the sentencing system, and it achieves the savings we wanted. When I want to exercise a U-turn, I shall give the Honourable Lady notice in future, but this is not such a manoeuvre.
Mr Stuart Jackson.
Speaker, the opportunistic shroud waving of the opposition obscures the fact that under Labour they never enacted the 1996 Prisoner Earnings Act, which would have meant and allowed victims to be compensated by the work of prisoners. Will my right honourable friend confirm to me the very welcome news to my constituents that vexatious, long drawn out and costly taxpayer funded immigration appeals are coming to an end?
Well, I am grateful to my honourable friend for welcoming our moves on prisoners' earnings and the use of those earnings to support victims. And I agree with him. We have too litigious a society, and we shouldn't have a legal aid system which just contributes to that. And I think our legal aid reforms are much overdue, actually, and will get us back to looking at more sensible ways of upholding the rights of citizens and enabling them to settle their disputes.
Angela Smith.
Mr. Speaker, is it not the case that this U-turn on sentencing will mean that some of the long-term savings planned by the Justice Department will no longer be achievable? And if that's the case, which other parts of the Justice budget will be cut to compensate?
Well, very roughly, the reductions we're making in spending are from £9 billion a year to £7 billion a year. The discount for early guilty pleas was meant to contribute about £100 million of that. What they move away from indeterminate sentences to a more sensible, determinate sentence-based system will, in the long run, actually save quite a lot of money, because we at the moment got thousands of people in prison who no one has the first idea when or if they're ever going to get out. And so, of course, we have to readdress. Now we've consulted, and we have settled the financial position now with the Chief Secretary, and we'll look for more efficiencies and savings. And I am quite confident that we will do so, because we, so far, are making very good progress in making very considerable reductions in the bloated expenditure that we inherited.
Mr. Mike Crockart.
Thank you, Mr. Speaker. Does the Secretary of State agree with me and my previous experience, not only as a wishy-washy Liberal, but also as a previous serving police officer, that one of the major barriers to rehabilitating offenders is actually the Rehabilitation of Offenders Act? 37 years is quite long enough to wait for reform in this. When shall we see it?
I hope soon. I take on board the honourable member's views, which I have considerable sympathy, and we do have the workings of the Rehabilitation of Offenders Act and its impact upon reoffending and rehabilitation very seriously, and policy is at the moment being finalised.
Diana R. Johnson.
Speaker, will there be specific provision within the bill in relation to children and legal aid? And in particular, will children in the care of the local authority be able to access legal aid to challenge decisions of the local authority?
No, again, I'm indebted to my honourable friend, the member for Huntingdon. We have changed that in the direction the lady would like in response to the consultation. The answer is yes.
Jason McCartney.
Thank you very much indeed, Mr. Speaker. I particularly welcome the plans to introduce a full working week across the prison estate, and particularly that the money earned by prisoners will go towards supporting victims. As a former RAF officer who is involved in convening courts-martial, I was wondering what opportunity my right honourable friend has had to look at the work ethic in the Military Corrective Training Centre in Colchester.
Yes, well, I'm grateful for my honourable friend's welcome for our policy. I mean, let me underestimate, it's going to be very difficult extending the work ethic and this work programme throughout the prisons. It will steadily be achieved, but we're embarking upon it. There are good examples in the prison service now, one or two, where a working week is actually in place for the prisoners. That just needs to be rolled out throughout the estate, and I certainly will take advantage of looking at the approach in the military prisons of their very work-based ethic there, which I understand to be the case. I haven't visited one for very many years.
Mr. Kevin Brennan.
I'm beginning to wonder whether it was a mistake to separate out the Ministry of Justice from the Home Office, because we now seem to have one ministry for arresting people and another one for letting them go. And I wonder whether he might go the whole hog if he wants to get rid of his reputation as a wishy-washy Liberal and rename his bill the Legal Aid and Punishment of Offenders Sentencing, Hang 'em, Flog 'em and Bircham Bill. That might satisfy the honourable members behind it.
Well, I have to admit, I thought it was a rather extraordinary way of reorganising the departments when it was first done. So did the judges. They greatly resisted going into the Department of Justice because they could see that the vast explosion of expenditure on prisons was going to crowd out the budget for the courts. And the Ministry of Justice is a bit like a cuckoo, a nest with a cuckoo in it. Politicians, certainly when... It's not me. under the previous government, They just kept feeding the prison service, exploding the prison service, and then cutting back expenditure in every other aspect of the department's activities as it was thrown out of the nest. We need to stabilise the prison population, get the costs under control, use it more effectively, and have a more intelligent way of working with the rest of the department to deliver things. So the long-term future of departments can be looked at. In my experience, the reorganisation of departments hardly ever achieves any worthwhile objectives, whatever the Prime Minister today thought he was achieving. Too much confusion is caused by moving them all around, and it's rather best to stick with the structure we have. But I wouldn't have done for this structure in the first place if I'd had anything to do with it.
Mr. David Mowat.
Thank you, Mr. Speaker. Even after these changes, we will be spending between 4 and 10 times as much on legal aid as other countries, some with similar jurisdictions as us. Does this not imply that there's a structural issue within parts of our legal system? And is there not more that we could do to address this structural issue in the years ahead, in which case we would make real savings?
Well, my older friend talks common sense about just where we are with the legal aid system. I still think it's important to have a legal aid system to enable vulnerable people and people at serious risk to protect their rights, even when they can't afford a lawyer. But there are plenty of other things wrong with the justice system. We again are bringing forward proposals to try to improve the efficiency of the courts. I don't think the courts at the moment provide a daunting experience to any member of the public who finds himself unlucky enough to have to go through any form of litigation. The delays, waste of time, cost are almost endemic in the system. And we are tackling the efficiency of the criminal justice system, but it applies to the civil justice system just as much, to try to make sure that the whole legal process becomes part of the public service. And it's actually there to be used by people who have to use it, or to do justice when someone has to do justice in the case of a crime, with rather more efficiency and rather more daunting waste and inconvenience than is often posed at the moment. And the costs really do have to be brought down through large parts of the service.
Mr. Ian Lucas.
Thank you, Mr. Speaker. The Lord Chancellor is a respected parliamentarian, and it's become increasingly clear during the statement today that he really does not agree with the sentencing policy that the Prime Minister has foisted on him on the question of reduction of sentences. Why doesn't he be honest, be true to himself, retain respect, and tell the Prime Minister where to go?
The Prime Minister and other colleagues in the government and I have all had perfectly reasonable discussions about the criminal justice system. We presented exactly the same package. We all presented a package of proposals for consultation, and we're now presenting the same package today in response to that consultation. This is a sensible way of running a government, and I realise that politics now today has become a branch of the celebrity culture. But all this idea that what is really interesting is whether the Prime Minister and I are arguing, whether the Prime Minister and I are agreeing, is rather surpassing what I think is an extremely positive package of proposals which is better fitted after consultation to meet the aspirations we all had when we embarked on the policy in the first place.
Jessica Lee.
Thank you, Mr. Speaker. It's a sad fact that half of adults leaving prison then go on to be reconvicted within 1 year of their release, as a legacy left by the last government. I therefore welcome the proposals for a working programme inside prison for offenders. And will my right honourable friend agree with me that this surely should provide prisoners with a brighter future and also prevent them from becoming a menace to society again, not least to the law-abiding citizens in Erewash?
No, I agree entirely with my honourable friend. The figure is truly extraordinary, that she repeats again, 1 in 2 will be convicted, actually caught and convicted, within a year of leaving. And I agree that proper change, firstly, will protect the public against the worst of that. And where there are people in prisons who've got the gumption to respond and try to get themselves out of their way of life and try to return to honest citizens, we should make more of them do so, and I'm sure that will be appreciated in Erewash as across the rest of the country.
Mr. Jeremy Corbyn.
Thank you, Mr. Speaker. The Secretary of State invited us to look 4 years down the line as to what the situation would be. Does he not expect there will then be a larger and more expensive prison population, with prisoners serving very long sentences for some of the offences where he's reducing the tariff or increasing the tariff, And secondly, that there will be large numbers of people denied access to legal aid, there will be fewer advice services, fewer CABs, and a lot of people very disgruntled that justice is not available for them because they're too poor.
Yes. I always believe that policy is best judged by results, which is, and half the fuss that surrounds the making of policy tends to completely fail to predict what goes right and what goes wrong thereafter. I firmly believe, I am quite confident, that this package of policies will not have the results the honourable gentleman fears. We will both know in 4 years' time. But the whole object of this is to achieve the precise opposite of what the honourable gentleman holds up as the possible outcome. We had to have radical reform. That radical reform has to be carried forward in a business-like, sensible way to deliver a criminal justice system and access to civil justice of the kind we require.
Mr. Richard Graham.
Thank you, Mr. Speaker. My constituency, Gloucester, will welcome the Justice Secretary's announcement today that serious sexual offenders, like those recently convicted for rape and assault in Barton Street and Eastgate Street, will now serve 2/3 rather than a half of their sentence in jail. And they will welcome the fact that illegal immigrants will no longer have access to taxpayer-funded legal aid. Does my right honourable gentleman agree with me that successful drug and alcohol rehabilitation programmes run by organisations like the Nelson Trust in my constituency in Stroud have an important role to play under these new policies?
Well, I agree with my honourable friend. It's far more sensible to have an appropriate determinate sentence, and for the longer ones, who will be the serious sexual and violent offenders, we should go back to them serving 2/3 before they're eligible for release, and indeed, if the parole board think they should not be released, probably serve the whole term. It's far superior to this lottery of the IPP which we have at the moment, and I strongly agree with my honourable friend that we've got to do something to encourage the more successful of the very many people in the voluntary sector who want to do work with ex-offenders and do something to help those that can be rehabilitated to actually get themselves out of a life of crime.
Mr. Peter Bone.
Mr. Speaker, parliamentarians on both sides of the House will not only welcome the Secretary of State's statement today, but the whole process. To be helpful to the Secretary of State, could he not solve the economic problem overnight by sending the 11,000 foreign national prisoners who are incarcerated in England and Wales back home tomorrow on a plane and forget their human rights?
Well, we do have some measures in the consultation about the release of foreign national prisoners after their tariff and so on, and conditional cautions for people who will go away on the basis we're not going to let them come back again, to reduce the rather ridiculous proportion of the prison population who are foreigners. We're working with the Borders Agency in what is actually the difficult problem. How do you get people out of the country when they've got no papers and the receiving country won't receive them and so on? But my instincts are entirely those of my honourable friend. It is to have 13% of the prison population who are foreign nationals is quite absurd, and we do have to work to get it down.
Order. I'm keen to accommodate remaining backbenchers, but I reiterate my ritual appeal for brevity. Dr. Sarah Wollaston.
Mr. Speaker, with regard to legal aid for medical negligence cases, can the Secretary of State reassure the House that he's made an assessment that we're not going to end up transferring additional cost to the NHS Litigation Authority?
Well, we've got, obviously the NHS Litigation Authority have been involved in our consultation, but at the moment I see no reason why that should be the consequence at all. Indeed, I hope that the NHS will be spared some of the more speculative litigation that's taken place, where people are really hoping that somebody will pay up a kind of settlement in order to avoid incurring further costs of resisting the claim. In genuine cases, you have to ensure access to justice. Of course, they're very important clinical negligence claims, and we think the no-win, no-fee as modified system is the best way of doing it.
Mr. Martin Vickers.
Speaker, the Lord Chancellor said in his statement that public confidence in the criminal justice system is unacceptably low. Sadly, that is the case. Would he agree that only when sentencing policy more truly reflects public opinion will that confidence return?
Well, of course, and that's why I've stressed some of the measures that we're introducing today to try to send the right messages about serious violent and sexual crime and about knife crime, because actually no sensible or civilised person in this country suggests anything other than serious punishment for crimes of that kind. It is very difficult to win public confidence because, frankly, most people's contact with the criminal justice system in the course of an ordinary life is very sporadic indeed. And so, actually, most people don't know anything about indeterminate sentences or discounts for early guilty pleas or any of the things that we talk about here. And I do have a rather sad feeling that opinion polls, for as long as I can remember, have always said that people think sentences are too short and the criminal justice system is too lax. But sensible public opinion, we are their servants, and we are trying to reassure them the criminal justice system will indeed protect them as it should do.
Mr. David Evans.
Thank you, Mr. Speaker. Does my right honourable friend agree that time in prison should be time well spent, and therefore education and training are absolutely essential, rather than leaving prisoners just languishing in their cells?
I entirely agree. My honourable friend has expertise in this subject, and I am working very closely with my honourable friend and right honourable and honourable friends in the Department of Work and Pensions. What they are doing to improve the training, work opportunities of people in this country has to include ex-offenders, and we have to make sure that in parallel we do more to get our ex-offenders settled in work wherever the ex-offender is prepared to make the effort to get into honest employment.
Mr. Raymond Chishti.
Thank you, Mr. Speaker. First of all, I welcome the statement by the Secretary of State, in particular abolishing legal aid for squatters resisting eviction. Can the Secretary of State clarify how much was spent on this area in the previous 10 years?
No, I think I shall have to write to my honourable friend with that information. But I'm grateful for his welcome. I mean, plainly, I don't know whether anyone will oppose it. It plainly is wrong to have legal aid ordinarily available for people who, by definition, are squatting in properties to which they don't have a particular legal claim they can put forward.
Amber Rudd.
Well, I acknowledge the need for cuts to legal aid. Can I share my concerns with the Secretary of State about local advice agencies that sometimes provide essential local advice to the most vulnerable? And can I ask him to work closely with his ministerial colleagues to make sure that some provision is made for them so that they continue?
Well, I will take back to my ministerial colleagues the fact that several respected members of this House have raised this point quite strongly in the course of these exchanges. We are discussing it, and I think we know we have to respond to it. And which department will eventually announce the outcome, I'm not quite sure, because there are several departments involved, but we're all seeking to find a solution to it.
Paul Maynard.
The Howard League for Prison Reform's recent report on short sentences made clear that one reason for the devastatingly high level of reoffending on sentences under 6 months is the lack of adequate resettlement support for those leaving prison. In retaining shorter sentences, can the Secretary of State reassure me that more will be done to make sure that these prisoners are helped to have a useful, purposeful life after leaving prison?
Well, I agree with the analysis of my honourable friend. I mean, the reoffending rates are very bad for short-term offenders because they are just let out again and there isn't the follow-up that is given to more serious criminals. The problem, of course, is you can't just extend it. Short-term sentences remain suitable for some people. Indeed, there are people who don't really need help, but who will benefit from being put in prison life. Uninsured drivers, as one I was talking about earlier today, people who are otherwise respectable who take no notice of the law on driving whilst insured will soon take notice of the law if they're given a short prison sentence. They don't actually require rehabilitation when they're removed. They almost certainly won't drive without insurance again, most of them. The others, we are where we are. There are some people who leave you no alternative, the magistrates no alternative, because everything else is tried and they keep offending. But if we could get stronger community sentences and make them more friendly, magistrate-friendly, then some of the people my honourable friend is concerned about might be put into a more constructive path which will help them keep out of offending again.
Mr. Gavin Barwell.
As a London MP, can I warmly welcome my right honourable friend's proposal to introduce mandatory sentences for adults who use a knife to threaten and endanger? He will know that many knife crimes are committed by younger offenders, and can I implore him to send a similarly unambiguous message to those offenders?
Yeah.
Well, I think the message from the whole House is that we disapprove of the carrying of knives and the using of knives, and we keep striving to reverse what became, particularly in parts of London, almost a fashion for knife crime very recently. The offence we are going to introduce, I'm sure, will reinforce the message we're giving, and there is a whole package of measures on knife crime which my right honourable friend, the Home Secretary, has also announced. The Government will take my honourable friend's advice to give very high priority to this subject.
Mr Paul Uppal.
The Justice Secretary touched on the issue of clinical negligence, in particular cases where litigation costs can often far exceed the actual sum insured in the case that is liable. And to echo the sentiment expressed by my honourable friend, can you provide the House with any guidance on measures we can be introduced to actually have early resolution? In particular, often you find the NHSLA, trusts, GPs, consultants often loath to admit liability, leading to undue costs and delayed, protracted negotiations.
Well, a lot of that, of course, is in the province of my right honourable friend, the Secretary of State for Health. But I think a lot of people in the health service do realise that paying up quite promptly and settling claims when obviously someone's made a mistake, but fighting resolutely the ones which are being brought by people who are rather being speculative, is the key way to proceed. And many could be resolved by better complaints procedures or by attempts to discuss. And one of the things we are exploring is the early exchange of reports, so that both sides know exactly what the expert evidence is available to both of them, and they don't hold their own evidence back, and that paves the way to a resolution of the claim. So I'm sure everybody in the NHS is as anxious to see some progress on this as my honourable friend and myself, and perhaps making legal aid less available in this area will stop people being quite so litigious and make some people be a little more constructive about how you can sort out a proper remedy.
Andrew Griffith.
Thank you, Mr. Speaker. The Right Honourable Gentleman's statements about knife crime will be welcomed by my constituent, Yvonne Upton, who has been campaigning since she lost her son Connor to somebody who chose to carry a knife on a night out. Turning to drugs in prison, does the Right Honourable Gentleman agree with me that under the previous government, too many prisoners were on long-term methadone prescriptions, parked on state-induced dependency, and getting those prisoners drug-free with an abstinence programme is key to proper reform?
Well, there are people with better expertise on clinical expertise on drug rehabilitation than me, but I share my honourable friend's instincts. It is, we are seeking to make proper drug rehabilitation programmes work. There is obviously a danger that sometimes it becomes easier just to maintain people on methadone, which is going nowhere in some of the cases. I'm sure methadone does have a place in all this because people with more knowledge than me insist that it does. But what we're looking for is proper rehabilitation wherever possible, with the aim of abstinence and making someone drug-free.
Jane Ellison.
Mr. Speaker, can I warmly welcome the Secretary of State's commitment to making our prisons more drug-free. A constituent of mine who is in prison has become addicted whilst in prison and is desperate to get off his addiction, lest he be drawn into circles of crime on his release. Can he make a commitment to do more people like that who want to get clean and go straight?
Yes, I hope that we can, and of course we are, my honourable friend is looking very much also at drug rehabilitation services generally to people who do not offend, as well as to the population who get themselves into trouble with the law. It's a very important area. I think the majority of crime in this country is linked directly or indirectly to drug abuse of some kind. The majority of our prisoners have indulged in abuse of drugs shortly before their admission to prison. So it's quite essential that we respond to my honourable friend's plea that these programmes are supported and made more effective.
Mr. Jake Berry.
Constituents in my constituency of Rossendale and Darwin will welcome the Secretary of State's announcements that more life sentences will be available to judges when dealing with serious, repeat and violent offenders. Would the Secretary of State inform the House what sort of offences this will cover and specifically which repeat offences will eventually carry this life tariff?
Well, I think there will be an automatic increase in the number of life sentences when we get rid of IPPs. What happened when the indeterminate sentences were introduced is that some people were given IPPs who were in the really dangerous category. They had been convicted of offences for which life imprisonment is already the maximum offence, but some judges put them onto the new IPPs, and once we change it, they will put them back on life sentences. Indeed, the whole IPP experiment, I think, was a mistake. We do have indeterminate sentences in this country. They're called life sentences, and they're better managed, and they are the proper way of dealing with the most serious offenders, and I think some of the most serious offenders getting IPPs at the moment would in future get life sentences as judges always gave them before.
Rob Wilson.
Many of my constituents will want reassurance that victims of crime are going to be properly catered for in the new bill when it comes forward. What discussions has the Secretary of State had with the Victims Commissioner, and can he tell us a little bit about them?
Well, I have very welcome conversations with the Victims Commissioner from time to time, and I very much hope to involve her more closely than we have been in the development of policy, because obviously the concerns of victims should be at the heart of all we're doing. I'm glad to say the Victims Commissioner, Louise Casey, I was told as I came in, has just issued a statement about our announcements today. It's quite long, Mr. Speaker. I won't read it all. It is extremely... Oh, well, I'll just say the first sentence. I would like to offer a sincere welcome to the Government's response to the Green Paper consultation announced today. It goes on. And I will make sure that I try to keep her support, because I think making sure that we have victims' confidence in what we're doing is extremely important.
Mr. Andrew Percy.
Thank you, Mr. Speaker. Thank you. The transfer of foreign national prisoners is obviously not a simple issue, but last year Humberside Police and the East Riding of Yorkshire Council brought to my attention the case of an EU national who had committed 33 crimes against the good people of Goole, and we were told that deportation, if it did take place, could take up to 2 years. Surely it's completely and utterly unacceptable for any EU national to be in a British jail. They should be in their own country, in their own jails, and if there are any who are in our jails, following their release, they should be deported immediately.
Well, I'm glad to say there is an agreement on the transfer of prisoners within the European Union, which is coming into force, negotiated by the previous government, and is coming into force in November of this year, with, I think, 2 countries that have derogated from it, Ireland and Poland, off my head, who are delaying implementing it. But for the rest, I look forward to the proper transfer of prisoners. It means British criminals will be brought to our prisons to complete their sentences here, and we'll see who benefits, because foreign prisoners will indeed be returned elsewhere. It is obviously sensible, it's very sensible from every possible point of view, that the quicker removal of prisoners due for deportation is a matter we're constantly considering with the UK Borders Agency, though I do concede to the Borders Agency that it isn't always quite as simple in individual cases as it's made to sound. It's very difficult to get some countries to accept former prisoners, and it's very difficult, of course, to get some people to go to them. And sometimes their very identity and their very nationality is a subject of constant dispute.
Mr. Philip Holloway.
Should not judges and magistrates be made aware of the success or otherwise of their individual sentencing decisions by keeping them informed as to the reoffending rate of those offenders which they send down?
Well, we have a lot of work going on about the transparency of justice, the publication of local figures. I think we all need to know more in detail at a local level of what actually is being done and what actually is being the consequences are of the administration of justice in our locality. And I'm sure all the best magistrates would welcome some feedback with more information about what is happening as a result of their sentencing policy.
Order. Point of order, Mr. Hilary Benn.
Thank you very much, Mr. Speaker. Mr. Speaker, we have today, for the second week in a row, last week it was the Health and Social Care Bill, today it's the statement on sentencing and legal aid, had a written statement, followed by a Prime Ministerial press conference, followed by an oral statement. Now, it is pretty unusual, Mr. Speaker, to have 2 statements on the same subject on the same day, but do you share my concern that it is discourteous to the House, because it means that the media have a chance to question ministers, the Prime Minister in the last 2 cases on policy, before members of this House get the chance to ask questions, and as such it is not in keeping with the spirit of our rules.
Order. I thank the right honourable gentleman for his point of order and for advance notice of it. I have made clear my view that important announcements of policy should be made first to this House with the opportunity of questioning ministers. Although I understand the pressures of the 24/7 news agenda, that remains my firm view, and I am therefore uneasy at sequences of events in which a written ministerial statement is followed or even preceded by briefing outside this House with the opportunity to question ministers in this House by means of an urgent question or following an oral statement only some time later. The House will recall that on the 20th of July last year it asked the Procedure Committee to consider whether the rules of the House should be changed. The committee reported in February and the government's reply was published a month ago. There are thus matters awaiting resolution by the House itself. In the meantime, the Right Honourable Gentleman may be assured that I will remain vigilant in the House's interests and will be ready to use my powers to permit questioning or debate if I see fit to do so, and indeed for such period as I see fit. I hope that's helpful. Point of order, Mr. Peter Bone.
Mr. Speaker, further to that point of order, and to show that there's concerns on both sides of the House, and also to say to the Shadow Leader I did not think he went far enough. Last night on Sky News, John Craig reported not only the detail of the statement, he actually reported the media schedule. And the policy was reported in this morning's newspaper. That clearly cannot be in order with current practices, sir.
And I note what the Honourable Gentleman has said, and I think that the House will have noted it as well. I don't think I need to add to what he said, but I'm grateful